Hello! In this video from the Justia webinar, Law Marketing Ethics Issues in a Race for Clients, Micah Bookdahl, president of HTML Lawyers Incorporated, discusses ethical standards and enforcement within the legal marketplace, as well as reviewing some digital marketing tools. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So what are the ethical considerations that we're talking about here today? This is a slide that I've used for years. The difference is that up until probably maybe even a year ago, I would spend 90% of the time of this hour on number one, attorney restrictions. Okay, this is what you need to do. This is what you need to do in such and such a state. We talk about not wanting to create an attorney-client relationship and competence and confidentiality and making sure we avoid conflicts, right? But then those next four things that were always kind of things that I kind of threw out there quickly. Unauthorized practice of law, multi-state jurisdiction, concept of solicitation, fee sharing. I kind of throw that stuff out there. Today, this program is really more about 6, 7, 8, 9 than number one because of the way that states are looking at marketing and advertising today. The issues have changed. And so that's what I want to talk about. When we're talking about the rules of professional conduct, the model rules, which again vary by state, different content, different comments, but these are usually the rules I'm looking at, somewhere between 7.1 mostly and 7.5. So if I were doing this program 2 years ago for you, it would all fall under this slide. I would just have like 20 slides dealing with this subject matter. But if you're new to this area, and if you're a rookie to marketing ethics, I want to kind of like run through some of these things that, that I consider an afterthought, but you might not. Okay, so what are we talking about when we talk about basics in marketing ethics? Disclaimer language. Okay, I still am amazed that every once in a while I get to a law firm website and there's no disclaimer. You have to have disclaimer language. Depending on which state you're in, there might be specific words or sentences that are required to have there. But you need to have disclaimer language. You need to say that you're not providing legal advice, that you're not creating an attorney-client relationship, that you might, send, if you're not licensed in a particular state, that you're going to send them work elsewhere, etc. The concept of wordsmithing, which is, again, the use of words like expertise and specialization, things that bars do look at and they do come after you for using the wrong wording, the wrong language. And I call it wordsmithing. When I go through a law firm's content and go, we got to change that sentence, we got to change that sentence. The concept of deceptive and misleading, which is really kind of like the central component of evaluating a law firm ad 95% of the time. Is it deceptive and misleading? And always the reminder that I give people that just because what you say is 100% true doesn't mean that you can say it. Okay, it can still be considered deceptive and misleading. The rules that vary regarding testimonials and endorsements. Okay, there's states where, you can do them. There's states you can't. There's states where you can do them, but with additional disclaimer language. There's, rules in regards to endorsements. These vary. The concept of ad approvals and pre-approvals. There aren't many states that require ad approvals anymore, but they're a pain in the neck. They're horrible. And so when you're looking for ad approvals in Louisiana, sometimes in New York, certainly in Florida, Louisiana, like again, they take time, they're costly. You have to write a check when you send in the ads, and you want to really evaluate what you need to get approved and what you don't. I already talked about the concept of available for employment, and also the concept of retention policies. Just remember, if I feel like I saw an ad and I was misled and I go to file a complaint with a disciplinary board and I say, I was listening to this radio station, I heard this commercial from this law firm, it was in February of 2023 during the morning drive on WIP. That law firm is required to provide that commercial, okay, the script of that commercial, and they should have a record of it. They should know exactly what commercial ran and when they ran it. So the concept of retention policies, which range from 0 to 5 years, depending on which state you're looking at. And then these all fit into the concept of, again, websites. We talked a little bit earlier about blogs and the concept of whether or not, I treat a blog mostly like a website. Okay, like I have a blog, I have a Justia blog, it's great. I'm not the greatest blogger in the world. I don't pretend I am, but I'm not doing it out of the goodness of my heart, right? I'm doing it to promo. Okay, so the concept of whether a blog falls under advertising, I feel like it does. Newsletters might. I can do an entire hour on ratings and rankings, online reviews. We're going to talk a little bit about billboards, TV and radio, social media, all these things that come into play. And you look at the one list and compare them to the rules of professional conduct that I already provided you. So what happens let's talk about real life, right? Like we always hear these rules. Do they enforce them? Do they care? How does it really work in real life? How do you end up with a grievance letter? How do you end up in trouble in this space? Okay, now I have the consumer as number 1. Consumer should actually be number 4 because it's the least likely person to create a grievance issue for me. Okay, the rules are really created with the consumer in mind, right? Aren't they there to protect the consumer, the uneducated person, in terms of understanding how you hire a lawyer? And so the rules are supposed to be there to protect the consumer. The reality is that consumers very rarely ever complain about any of this marketing. Okay, it's almost never. There are a couple examples that I've seen dealing with online reviews, a couple of other things, but for the most part, consumers don't complain. And the reason they don't complain goes back to that archaic National Law Journal op-ed piece that I wrote, which is that consumers know something. You know what they know? That it's a commercial. Okay, that I'm marketing, that I'm advertising, that it's puffery, right? And so they don't believe, they don't look at a billboard and go, oh, that must be the best lawyer in the world. Okay, just like they don't say that must be the best diner in the world or whatever other billboard you pass by. So the concept of the consumer is supposed to be number 1, but in reality, they don't complain because they know it's commercials. They know it's advertising. They know it's marketing. Okay, they know what it is. My friend Tom Spahn and McGuire Woods, we talk about this all the time. He always gets so frustrated. He's like, consumers know what a commercial is. All right. So number 2, the state bar disciplinary arm. Most likely the people that are going to come after you, right? Okay. And so there are proactive state bar disciplinary arms. They're reactive, and there are states that could care less. Okay. They're states where I never have seen or heard anything from them. They don't care. They treat it like I just mentioned in regards to the consumer. Oh, it's marketing, whatever. Okay, so the state bar disciplinary arm, in states in which they are potentially proactive. So where are they proactive? They're proactive in like Florida, right? They're proactive in Florida. They might go and find your ad on their own and decide that they have an issue with you. There are a number of states that are proactive about it, but they're the ones that they'll find your ad, they'll find your social media post, they'll find whatever, and they'll take issue with you. Maybe you didn't file it. Maybe you're engaged in unauthorized practice of law because you don't have an office there. Whatever it is, they might come and find you and reach out and create the issue, create the grievance. Number 3, responding to an attorney complaint. That's probably, there are probably as many of those, if not more, than number 2, right? Okay, so an attorney says they look. They see a competitor. They see somebody else in their space. They're like, that violates 7.2C, and they complain. So I get a lot of my clients who will, every once in a while, they'll say like, oh, look at so-and-so's website, or look at so-and-so's billboard, or look at so-and-so's advertising. We should turn them in. And I'll usually say like, sure, go ahead. Just make sure you don't live in a glass house. And that's what I usually say to most of them. I'm going to, because a lot of us live in glass houses. So before you go turn them in, make sure your hands are not just clean, they're like super clean. Because I can probably go on almost any website of any law firm and I will find an ethical violation. Okay, most people won't, but I'll find one. I can find one. And so responding to an attorney complaint, number 3, and then complaints by defense counsel and in-house counsel, which a lot of people aren't aware of this. Like, defense counsel have started to use the advertising rules as ways to hit back at the plaintiff's bar, at the plaintiff's attorney on cases. It's really fascinating to see. And so they'll sit there and say, hey, that law firm that's representing the plaintiff, they violated the rules of professional conduct. Okay, their advertising is inappropriate. As a matter of fact, they shouldn't even have this matter because they used inappropriate advertising in order to get it. And so this is something that I've seen more and more from both defense counsel and often the in-house counsel on the opposite side, where they started hitting back by looking at the advertising rules and determining that you got the business or you're involved, either engaged in the unauthorized practice of law or in violation of a number of the other RPC rules in a particular state. It's a really fascinating thing to see. And then who enforces these things? State bars and the courts, sometimes consumer protection laws, every once in a blue moon, a criminal case. And then there's other external forces, right? Like other people that police the area, okay? Like how many law firms are afraid of getting dinged by Google? Oh my God, we're going to get punished by Google, right? Like that's worse than a disciplinary matter, right? Like getting punished by Google. And so there are other external forces, the Better Business Bureau, outside of the practice of law. And different types of sanctions. You got to be really bad to get in big trouble. You know, most of the time, if it's a first offense, you fix it and you don't do it again. If it's a second offense, definitely don't do it again. You know, if you keep doing it, sometimes you're doing it on purpose. I've seen firms that do challenge the state bars. You know, now you're going to start getting yourselves into trouble. But most of the time, you know, if you haven't gotten in trouble before and it's sort of a first time thing, you know, you basically go and you fix it and you make sure it doesn't happen again. That's one of the first things I say to a lot of my law firms when we sit down is I say like, hey, have you ever gotten dinged before? Right? Like, have you ever gotten called out before? Because if you have, it kind of changes the way that we're going to look at things. But the different things in regard to sanctions. So I talked about how I used to skip over solicitation. Like, you know, I would talk about solicitation. Why? Because we know what you are and are not allowed to do, right? Like we know what solicitation is. I know I can't run over to an accident scene and start handing out business cards. I know that. I know I can't call the home of a victim, right? Like I know I can't do these things. We all know what solicitation is. But people have started to change the way solicitation is interpreted. And this is an area that's really red hot in terms of various state bars starting to change the terminology, change the way they interpret solicitation. Okay, so here's the rule. Directed to a specific person the lawyer knows or reasonably should know needs legal services. That is a solicitation. Let's compare what a solicitation looks like right now to the way it was pre-internet. And really the law as it exists today, according to the U.S. Supreme Court. Florida Bar versus went for it in 1995. It's really the sort of the preeminent solicitation case in which, you know, and it was basically a 5-4 decision. If you basically put this case in front of the Supreme Court today, you flip it, all right? Like the decision's completely opposite. So, but in 1995, Florida Bar versus went for it. They looked at it and they upheld the 30-day rule in terms of contacting people in regards to solicitation in, you know, sort of you know, in sort of mass tort or you know, hard, you know, difficult disasters, right? So, you know, Florida Bar versus went for it. They basically, the Supreme Court says yes, the 30 days goes, right? And so lo and behold, like the very next year, you get the value jet crash in Florida. Okay, so it immediately puts the Supreme Court case right to the test. And what they found, as you can see in this New York Times article, is that lawyers were ignoring the solicitation ban. And so, you know, they basically were just, again, going out there, going to the hotel, contacting victims' families, all the things that happened. So that was the way, you know, those were the issues. The issues are still the same today, but they're a little bit different. So last year, ABA Formal Opinion 501 dealt with solicitation and the issues dealing with it. One of the things that I found interesting about 501 is that people found it interesting, right? Like I thought, like everything that I read in 501 dealing with solicitation, yes, I know, right? Like to me, it was second nature. But to some, it was a wake-up call. So what happens in 501? What do they talk about in regard to solicitation? You know, one is that one is that live person, like just a reminder of what you are and aren't allowed to do. All right. So what are you allowed to do? No live person-to-person communication unless you carve out one of the exceptions. That you're dealing with a lawyer, you're dealing with a family member, you're dealing with people that you have a past relationship with. Those are kind of the exceptions, which again I consider to be sort of something everybody knows. The key part of 501 in solicitation is dealing with taking responsibility for the actions of others. In that ValueJet crash, like 2 lawyers that got suspended, they got in trouble because their staff were handing out brochures at the hotel. Okay, and the lawyers argued like no lawyer was ever there. Okay, their employees were there. And so they were responsible for the actions of their employees. That's no different today, right? Like you are responsible for the actions of others, your marketing department, your employees. But beyond that, you're responsible for those third parties that you engage for marketing services. Okay, lead generation companies, digital marketing companies. You're responsible for their actions. Believe me, I know there are plenty of times where I've been told by a law firm that gets a grievance letter, they're like, oh, our digital marketing guys did it. I had no idea they were doing that. And I'm like, so? I don't care. The state bar doesn't care. It's your responsibility. It's the lawyer's responsibility. And that's sort of the key. And it comes into play because of the way that a lot of the lead gen and competition has changed. So when we talk about lead generators, believe me, a lot of the lead generators out there, a lot of them are credible. Some of them have come to me for help. But for every lead gen company that's legit, there's one that operates sort of outside the scope of the rules of professional conduct. And so you have to be really careful when you're dealing with companies and you're buying leads. And so, what is it that we're buying? Are we paying for a lead or is it something else? Okay, so paying for a lead is okay. You're allowed to pay for a lead. Paying for a client referral, not okay. You look at whether or not a lead is really a disguised referral, right? Like, is it really a referral that you're calling a lead? You can pay per lead, but not per client retained. So you can't pay for a retained client. You can pay for the lead. So one of the things that some states look at is the dollars offered. So if I give you, $500 for every lead you generate, okay, maybe I consider that credible and that's legit. But if I pay you $7,500 for every lead generated, now I'm going to look at it and go, that's not a lead. Okay, that's a referral. And so you want to look at the variables that exist there. Is a non-law firm company providing legal services? You need to look at that because there are companies that get in trouble for that. And you, by virtue of hiring them, retaining them, are now in trouble. And is there impermissible fee sharing? So these are all the things I look at. The example, by the way, that I have up here on the screen, this is an email that I received to my Yahoo email account on Camp Lejeune, okay, one of the biggest mass tort out there right now, right? And so Camp Lejeune, I get these emails, last call Embuchdahl, okay, and it's from a law firm, okay, but I never gave you permission to send me an email. I never told you you can reach out and contact me. There are a lot of times that we get emails from people, but a lot of times the emails are generated by lead gen companies that are using unethical means to generate the lead. And so these are all the things that I look at. When I talk to digital marketing companies, I talk to them. Sometimes I don't want to know how you generate a lead, to be honest with you. All right. Sometimes I'll be like, forget it, I don't want to know. But a lot of times I do ask a lot of questions about how these things are created and how they're generated. There was one company that I was looking at not too long ago that was bragging that they were, for lawyers by lawyers. And so I said to them, I go, well, does that mean that you abide by the rules of professional conduct? Are you saying that you're taking responsibility? Okay, I can't dole off the responsibility to them if something goes wrong, but I'll sue you, right? So what ends up happening is, so a lot of times they'll suddenly walk back. Well, I can't really guarantee you this, or I can't really promise you that, but, always be aware of, what you're buying in the lead gen space, and look and see whether or not it's legit, right? So I don't really know this outfit, but it captured my imagination when I was looking at slides. Choose the best lawyer. And so again, this is generating a lead for someone. And it's not really clear. It says, how does it work on that slide? I can't really tell how does it work. I'm not sure how it works. I don't know how you get in their 5-star network of lawyers. But maybe I'm wrong, but my guess is that if I have the money to be in the network, I'm in. And if I don't, I'm not. All right. And so one of the other things I looked at too is as I went through the intake form, which is another area that I always look at, the intake form and the disclaimer language tied to it. It has a consent to contact. There is no consent. There's no language. So I'm clicking on, I accept the terms of the consent to contact disclaimer, but I couldn't find a disclaimer. So I couldn't find the text, couldn't find the content. Okay, so I was concerned there. And I was also concerned about the ownership, you see at the bottom, of consumer financial services, as if it's almost like a consumer reports type entity. But it's not. And when I went to search for consumer financial services, that's not the name of whatever the outfit is. And so you want to look at all the things that are sort of tied to it. Again, this might be a completely, fine outfit. But what I could see and what I couldn't see bothered me, and I would not let one of my law firms sign up here unless I had a lot more information. So when you talk about how personal injury lawyers, despite all the things that we talk about, we're still the biggest advertisers going, right? So regardless of whether or not I stand by it, over $1.2 billion was spent on personal injury law last year, $206 million on mass tort advertising. One of the things about personal injury law and the reason it's so effective when it comes to advertising is they're usually one-offs. You're not usually creating a relationship. Like, I didn't have a lawyer before. I needed you for this, and I'm not going to need you for something tomorrow. And so the concept of one-offs creates the whole idea behind what you aren't allowed to do. So I live in Philadelphia. I live right outside of Philadelphia. And so Jeff Rosenbaum, who, basically is an aggressive marketer. I've never met him. I don't know his law firm outside of his commercials. They run a lot of commercials, a lot of billboards. But he's taken great offense from, John Morgan at Morgan & Morgan. Okay, so, I can't speak for him, but I think he kind of hates him, right? Like, so, they consider them competitors. They don't consider Morgan & Morgan to be a Pennsylvania law firm. And they're coming in and they're taking your business, right? They're a marketing engine. And so he ran like this billboard where he just puts up John Morgan's picture and says, Florida lawyer, not licensed in PA. And so it's a highlight of the way that the market's changed and the sort of the competitive nature of the market. So how does the market change? Yeah, I don't know Morgan & Morgan. I've never had any personal interactions with them. I've met them at a couple conferences, some of the folks. But they're a huge marketing machine, right? Like they're all over the place. I don't know if they're in every market in the country, but they certainly seem to be. And they generate leads and they generate clients, and they know where you're allowed to practice or where you're not. They're not sending, the John Morgan in Florida is not touching the case in Pennsylvania. There's somebody in the Pennsylvania office, right? But the concept of Morgan & Morgan and there are other law firms that sort of take that national scope and sort of eat away at market share. There's a very well-known divorce law firm that markets nationally. And have ruffled feathers in a number of states because, again, like they're taking market share away from locals in various places. So that's one area of competition that we've had to kind of deal with and interact with. Then the concept of the virtual law practice. So this is a virtual law firm. So when you have a virtual law firm, what rules of professional conduct are you following, right? Like all of them, none of them, some of them. And so I had a virtual law firm call me, and I was looking at their website, and I was talking to them, and I said, you list 15 offices. It says here are 15 offices. Now, the 15 offices are really 15, most likely individuals in 15 different states that handle these corporate matters. I said, but, the way it's set up here, like you need to abide by the RPC for those 15 states. Like, did you send in your ads for pre-approval and for the stuff in Florida? And so they, and I can tell you, like, they had no idea what, either they were ignoring it or blinders on, whatever. But the concept of virtual law practice really sometimes creates sort of an uneven playing field, because if I have to abide by all these rules and the things that I do, like, why don't they? And they're licensed in whatever state. So that has increased competition. And then competition outside the scope of other lawyers. Okay, so those are examples I just gave. Those are other lawyers. But what about non-lawyers offering legal services? And so you've probably read about the world's first robot lawyer, because they've gotten in lots of trouble of late, from Do Not Pay. And Do Not Pay was trying to say, like, you don't need lawyers. Like, we can basically handle everything for you in your suit. And that doesn't really go well with within our profession, when people tell you you don't need lawyers anymore. And so they actually were promoting that they were going to have a robot lawyer actually represent someone in court. And that never happened. But now there's a proposed class action lawsuit claiming that Do Not Pay has been practicing law poorly and lacks a license. So the complaint argues, unfortunately for its customers, Do Not Pay is not actually a robot, a lawyer, nor a law firm. Do Not Pay does not have a law degree, is not barred in any jurisdiction, and is not supervised by any lawyer. So that's the class action in California that's going on, that was just filed recently, I think last week. But there are a lot of entities that are out there that are trying to basically practice law without a license. And so that becomes part of the competition that we have to deal with. And so that lends itself to what I said, earlier about Model Rule 5.5, which deals with UPL and multi-jurisdictional practice. And those are the areas that are mostly getting hit when there are grievances regarding lawyer advertising. It's you're not authorized to practice law in this state. Okay, you're not barred here. You don't have an office here. And so the whole concept of, multi-jurisdictional practice. So if you want to read a really dense article I wrote in Law Practice Today, there's a screen capture. It's a point counterpoint dealing with, whether 5.5 will actually be changed to allow you to be licensed in one state and practice in all. I've said that'll never happen. It certainly won't happen. I don't think it'll happen in my lifetime. I'm not sure it'll ever happen. But it lends itself to the concept that, most of the things that we practice in now are multi-jurisdictional. They go across the board, and it becomes very hard to figure out where you need to be licensed, where you need to care about a license and rules, and where you don't. There's also, just recently, earlier this month, Formal Opinion 5.0 dealing with choice of law. And again, that sort of plays into the whole concept, same as unauthorized practice of law and multi-jurisdictional practice. What rules come into play? Who's in charge here? Let me go back quickly to explain, to tell you a little bit more about, multi-jurisdictional practice and, and the way it comes into play. So when a law firm has me review their marketing campaign, what am I looking at? I'm looking at what jurisdictions I have to care about. Like, do I have to worry about? And so I look at that. I look at whether a law firm has an office in a particular state. I look at who's licensed in those offices. One of the things that's often very difficult for state bars is it's hard for them to go after someone who's not licensed in their state. So it's very easy to sit there and say, like, so I'm in Pennsylvania. All right. So say I violate the rules of professional conduct in Michigan. Okay, and somebody files a grievance against me in Michigan. Michigan can't really do anything to me, okay, for the most part. Okay, they can then take the grievance and send it to Pennsylvania and say, hey, Mike is violating the RPC in Michigan. And so Pennsylvania would then likely investigate. Doesn't have necessarily the same impact, but it's very hard to enforce the rules in other states. It's also hard to enforce the rules against these companies that aren't members of the bar. So, for example, that class action suit for Do Not Pay, you would sit there and think, like, why doesn't the disciplinary board just shut them down? Because they're not lawyers. Because there's no lawyer to go after. So you always want to think about all those things. The other thing too is going back to the concept of the lead generation. and lead gen is that there are a lot of law firms that are out there that they're built just to generate leads. They're not even built to practice law. Okay, I was on a site in the last couple of weeks where I found it very remarkable. I went through the site. I couldn't find a single lawyer's name, and I couldn't find a single bar admission or location. Like, it was purposely vague, right? And so when I really looked deeply, sort of at the site itself, I kind of realized like it was really there just to generate leads. Was it really a quote unquote law firm? Yes, it was. Did I track down a lawyer tied to it? Yes. I looked him up, looked to see where he was licensed, looked to see if there were any disciplinary matters. But a lot of times these sites are purposely set up to not to not be able to figure out what state you're in, where you're licensed. I recently helped someone in a very niche personal injury practice out west, and they were really frustrated because they looked at the people that had the law firms that had the greatest market share in this niche. Their websites, I could tell you, had 100 ethics violations. They were engaged unquestionably in the unauthorized practice of law. I'm sure they did not file ads in the various states that they were going after business in. All these things. Yet they've probably operated in the same way for many years, and they probably will continue to operate in the same way for many years. And so that becomes really difficult. And so that's one thing that I always like to tell people about the rules and sort of the way that I approach them is that I'm not a letter of the law guy, okay, because the states aren't, right? Like, and so, it becomes really difficult when you're practicing in a space or you're marketing in a space and that nobody cares about the rules, or that others are flaunting them. And so these are all the things that sort of come into play. So just, I have slides at the end in case I ran short. I never run short, right? So, a couple things I want to point out real quick. Here's a recent ethics opinion in South Carolina dealing with expertise.com. Again, this is a website called expertise.com. You're not allowed to call yourself an expert. Now, if you go on expertise.com, there are lots of law firms that are listed for practice areas. They did not ask to be listed. They did not pay to be listed. So if you're listed on there, you do not get in any trouble. You are not responsible for that content. But if you paid to be on there, you are. And so, keep in mind that that's the concept of proactive engagement. When you see things on the internet that are tied to you, you weren't responsible for them, you're not going to be held accountable. Trade names, another area that's changed. Trade names are now pretty much allowed across the board, thanks to Law HQ and their various lawsuits. And so, so if you use a trade name, it used to be that you had to be careful because there were states that you weren't allowed to. Now trade names are pretty much allowed across the board. I could talk for an hour to this slide on ratings and rankings, just off of the New Jersey opinions. But again, different rules that come into play in regard to the use of ratings and rankings, methodologies, disclaimer language, etc. that come there. And then same thing with Google reviews, the power of a Google review, not just, the content itself, but also just the numbers. As you know, like the more reviews you have, the higher you go up in the rankings. And so the concept of a Google review, I can talk about that for an hour too. So recent model rule changes that we've talked about, they deal with technology, competition, cross-border, trying to be uniform, trying to make it more simplified. Yes, sometimes you do, sometimes you don't. And looking at public policy in terms of changing components of 7.1 to 7.3. And then if you love this stuff and you're just fascinated by it, okay, I invite you to go look. These are two handbooks that are available, on the websites of the Florida Bar and the Louisiana Bar. If you want to scare the hell out of yourself, go print out one of these books and go through it and try to figure out how you would ever comply with the rules in these particular states. They're great handbooks. They're really extensive and they're really thick. But when I read them, I'm thinking like, I'm not sure how I'm ever going to comply. And they're very difficult. And if you're really interested in digging even deeper, the Louisiana State Bar actually puts their filing system up online for anybody to see. And so I can basically go and look at everybody's ads that they've submitted for approval or pre-approval. And so not only can I see what gets rejected, but I can see what my competitors are doing. And so, I don't like this. Like if I'm a marketer, I don't like being able for my competitors to be able to go see everything I filed and know what's coming down the pike or what I have out there. So it's a fascinating area, the concept of the advertising filing search.
We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.